Welcome back to part 2 of our 3-part series on estate planning. So today we're really going to focus on how to avoid probate. So we still have our disclaimer because it's still important for you to understand that this is general information and that it should be helpful to you as you're thinking about creating or updating your estate plan, but you shouldn't take today's video in lieu of a consultation with an attorney who can become familiar with your facts, your circumstances, and really hone in on and create a plan that works best for you. Probate avoidance is a piece of the puzzle, but it's not the entire picture. And we would be happy to meet with you and have a consultation and talk more about you and your personal circumstances. So if you're interested in getting that consultation, feel free to reach out to our office. Otherwise, we hope today's content is helpful to you. So let's refresh our memory about some of the things we talked about last time. We kind of did an introduction of, planning for what happens when I pass away, and we talked to you about the role of a will in a comprehensive estate plan. So I think we should pick up on that conversation. And then we're going to compare a will-based plan with a trust-based plan, why somebody might choose one over another, and we'll dig into the probate process as well. So when it comes to will-based planning, I think it's really important to understand what a will does and what a will can't do. So if we start out thinking about a will as the instruction guide for how our estate will be probated, that's probably the best way to think about it. A will is an important legal document, but because it allows you to designate your wishes, and that's a really important concept when it comes to estate planning. So a will allows you to nominate a personal representative. In Delaware, we call that position the executor, but this is the person that you're putting in charge of your affairs. You're laying out the instructions, and this is the person who will execute that particular plan. Within your will, you also can leave instructions about where you want your assets to go. I think most of us think about that. But we should also think about what kind of instructions can I leave within my will. So off the top, you can include instructions about your tangible personal property. That's a fancy term for our stuff. It really represents things you can touch and move, things like the contents of your home, family heirlooms, jewelry, vehicles even, are things that are considered tangible personal property. For our Delaware clients, they're allowed to use a tangible personal property memorandum. That's a list of your stuff where you designate certain items that you want to go to particular people. And this can be a really nice and flexible way of saying who gets what particular stuff. So for instance, if I have a ring that's been in the family for years and I want my oldest granddaughter to get that particular ring, I could leave that on the list, and that list will direct where I want that possession to go at my death. So it's a great way of dealing with stuff. In Delaware, that list can be amended after it's first incorporated into a will. So I reference the tangible personal property memorandum within my will, and then I incorporate a future list that I'll create by reference. And what that gives me the position to do is to make changes to that list throughout my lifetime so that I don't have to see an attorney or secure notaries and witnesses every time I change who gets what stuff. I sometimes joke with my clients that this is the list that sits by my grandmother's phone, and when you call on Sunday, she can add you to the list, and if you skip a week, she can just cross you off the list. The idea is it's super flexible. It requires a signature and a date, but otherwise it can be changed as often as you'd like. For our Maryland clients, we don't have that particular option. So if you do have certain tangible personal property that you want to go to a particular person, you need to incorporate that within the content of the will itself. We can also make specific gifts. So specific gifts might be, I want a particular parcel of real estate to go to a certain person, or I want a bank account or sum of money to go to a person or a charity, something like that. So those are things, tangible personal property and specific gifts are things that sort of come off the top. These are specific designations that I want to make off the top of my estate plan. Within my will too, I always want to include kind of a catch-all or residuary provision, and these are the general gifts that we can include. So if we think of everything else as sort of falling into a pie, and I'm going to slice that pie into pieces and designate who gets what piece of pie, that's sort of how that residuary provision works. It also allows me to name contingent beneficiaries. So if the person I've designated first to get that piece of pie isn't living at the time that I pass, I can designate who the next in line would be. When we create a will, it can be filed for safekeeping before we pass away, but it's not filed and sort of opened as an estate until after I pass away. And my executor has the responsibility of filing that will and my original death certificate, along with a petition seeking to be appointed as executor with the local register of wills. So the will is sort of activated when it's filed with the Register of Wills, and the Register of Wills has the responsibility of overseeing the probate process. Probate is what we call that process where we're sort of relaying or transferring assets from my estate to those I've designated. So my will instructs how that's going to happen, but probate is the Register of Wills overseeing my executor following those particular instructions. So before we dig too much into probate itself, how it works, what's involved, I think we should just kind of recap some common myths that we sometimes hear about wills, because it's important to know what a will can do. It's also important to know what a will can't do, so that you can fully address your estate plan. So wills do not avoid probate. We've learned today that they are really an instruction manual for how the estate will be probated rather than a tool to eliminate it. Also, the will doesn't control disposition of all assets. So what I mean by that is I may have assets that are owned in a way that my will won't control, because my will only controls things that I had an interest that could be conveyed in. So if I own assets that are jointly held with a right of survivorship, those assets are going to pass to the joint owner outright, separate and apart from what the will says, because it doesn't come into my estate at all. It actually passes to the joint owner by operation of ownership. We can do that with real estate. When real estate has a right of survivorship, or if we own it as husband and wife, we call that tenants by the entirety. Those are instances where that real estate might be reflected on probate documents, but it's actually passing by operation of title. Other examples might include if I have a joint bank account, or if I have a bank account or an investment account that has beneficiaries listed. Sometimes those beneficiaries are listed as beneficiaries. Sometimes they're listed as what are called transfer on death or pay on death designees. Those are all ways of naming people to get an asset directly after I pass away. So where people can get themselves into trouble is they have owned their assets in a particular way over time. Maybe they added joint owners for convenience purposes, thinking if something happens to me, I want my oldest child to have immediate access to be able to pay my bills. So I'm just going to go ahead and add them to the account. Not thinking about the fact that that means that one child might end up with that asset, when my true intention is they have access during my lifetime, but it's divided equally among all my residuary heirs when I pass away. So the will controls things that are in my personal name. That's what falls into my estate, and the will controls disposition of my estate when I pass. But if I haven't updated beneficiary designations or joint ownerships in a way that are consistent with how I want that estate plan to work, I might have an estate plan that doesn't work the way I thought, because my will says one thing, but my ownership and my beneficiary designation say something totally different. So it can cause this sort of misalignment of intentions. Wills are helpful because they cut down on the risk that there's going to be contention within the family, litigation within the family, because a will conforms to certain legal requirements. So there's a presumption that that will says what I wanted to happen and that it's legally enforceable. So it can kind of squash or cut out some conflict. But wills don't reduce administrative expense. Administrative expenses when it comes to estates a lot of times relates to this idea of probate and the process of overseeing probate or estate administration. And since the will is really just an instruction manual, it's not eliminating all the hoops that my personal representative or executor have to jump through in order to accomplish the objectives that I've given to them. So let's talk about what probate is. So again, right, anything I own, I have an individual interest in, it's going to fall into my estate. Now, when we are filing certain legal documents with the Register of Wills, sometimes we have to report jointly held assets, even though technically they're not part of the probate estate. But the probate estate is really anything that I own when I pass in my individual name, even if I have a shared interest in real estate, but it doesn't pass by right of survivorship. So in order to initiate the probate process, a couple of things need to happen. The personal representative or the executor in the estate plan in the will needs to file the original will and a death certificate, along with some opening documents reflecting that they want to be appointed as the executor of the estate. All of that information needs to be reviewed by the Register of Wills before they'll even appoint the personal representative. And so sometimes there is a delay on the front end because the personal representative has a will that says they can act, but they don't yet have the legal authority from the Register of Wills that says that appointment has been approved. So the first thing that we see with probate is there's an initial delay until the personal representative can be appointed. Once they're appointed, there's multiple stages of filing that they have to conform to, and we're going to walk through some of that today. The cost of probate comes down to a couple of things. So there is a probate fee associated with the probate process. It's an administrative fee that's collected by the local Register of Wills that has that obligation of overseeing this process. The probate fee in Delaware is based on a percentage of the net probate estate. And so in Kent and Sussex County, that's 1.25%. For our friends in Newcastle County, that's 1.75%. In the state of Maryland, they handle it a little differently. They look at the value of the assets, but there's a tiered system as to how much that fee is going to be based on the value of the assets. So in general, the probate fee is tied to the value of the probate assets, whether you're in Delaware or in Maryland. The typical timeline for administration is about a year. And that comes down partially to this need to conform to certain stages of filing along the way, but it also comes down to a creditor period. So in each state, there's a period of time in which anyone who may have a potential claim against the person who passed away, they can file that claim at the Register of Wills, reflecting that they should be paid out from the estate. So in Delaware, it's an 8-month creditor period. In Maryland, it's a 6-month creditor period. That creditor period begins on the date of death. So if you're opening an estate, you can't close the estate until the creditor period has run. And typically it takes a little longer than that because there's extra filing that we have to, rules that we have to conform to. And it requires oversight or approval by the Register of Wills before the estate can be closed out or approved. In each state, there is a small estate process, and this just means it's an abbreviated process. So full probate requires multiple stages of filing, typically takes a year, requires us to wait out the creditor period. But with a small estate, what you're representing to the Register of Wills is the estate assets are so small and we've resolved any issues related to outstanding debts on behalf of the person that died. So we don't have to go through this entire process. So in Delaware, if I own assets that exceed $30,000 or an individual interest in real estate, that's what triggers probate. So a $30,000 threshold is really low. And so that's why most of us are thinking about probate avoidance, because most of us have assets that exceed $30,000 in value and or an interest in real estate. In Delaware, that small estate process looks like me filing the will and the death certificate and a small estate affidavit. That should be filed no sooner than 30 days after the decedent passed away. And it sort of gives the personal representative the ability to close accounts, satisfy bills, and take whatever money is left over and distribute it among the people who should have gotten it, whether it's the people who are designated within the will, or if there is no will, there's a default statute called the intestate statute that will direct where those assets will go. One thing about that small estate process is you have to affirm that all known expenses have been paid for. So if you have an estate that is insolvent, meaning there are less assets than there are debts to satisfy, you won't be able to file the small estate affidavit. In Maryland, it's a little more robust of a process, but a similar abbreviated process where it's more of a one and done filing. The thresholds in Maryland are $50,000 for a single unmarried individual and $100,000 for a married individual. So let's talk a little bit about the estate administration process. This is a flowchart that we use within our practice to help people understand what estate administration and sometimes trust administration can look like. So I'm going to focus on the estate administration or probate process. Phase one is what we talked about. It's this idea that I have the will, I have the death certificate, it says I'm appointed to administer the affairs of the estate, but I need it to be approved by the Register of Wills. So before we file those things, we're oftentimes reviewing the will with our client. Our client in the probate world is the personal representative, just to kind of make sure we've covered everything. We've got the right people filing the right paperwork, and we know who the backup people are, if any, within the document also. Unlike what you might see on TV, we don't have a formal reading of the will where we bring all of the family together to sort of hear the lawyer read off the will document. But we do absolutely review that will as we're considering who's going to be appointed as personal representative of the estate. So once everything is filed with the Register of Wills and the Register of Wills has a chance to review everything, they're going to issue what are called letters of testamentary. This is like the golden ticket for the personal representative so that they know they have legal authority. It's almost a court order that says you have authority to get access to the accounts, to liquidate accounts, to do everything that you need to do to fulfill your job as stated within the will. If a person doesn't have a will, we go through a similar process, but like I said a moment ago, there's an intestate law, a default law that controls who's going to be appointed and where the assets are going to go after debts are satisfied. If we don't have a will, we call that letters of administration versus letters of testamentary. It's just a change in language, but it really is giving that person the same authority. Once we have the letters of administration, we then are really formally opening the estate. So we're getting a tax identification number or an EIN number for the estate. We're able to open a new estate bank account. We're able to get access to assets that the person who passed away had during their lifetime so that we can start sort of marshaling the assets and deciding exactly what the decedent owned when they passed away. And that really transitions us into part two, this idea of safeguarding the property, notifying the beneficiaries. This is all really important. And I would say it's really phase one and phase two where the personal representative is sometimes feeling overwhelmed. There's a lot of work to do in the very beginning before we sort of sit and wait out the creditor period for the remainder of that 6 or 8 month period. So in phase two, after the personal representative is appointed, they have a responsibility to safeguard the assets. So they want to first determine what did the decedent own when they passed away. So we have to reach out to banks. We have to secure real estate. We have to gain possession of any vehicles, things like that they owned when they passed away. And we need to keep them safe. So we want to be careful with things like a vacant home. We want to make sure we have security systems in place. We want to make sure we winterize the house if the season has changed. So these are all very important things that the personal representative has responsibility to do right away. The other thing that we do, and we do this on behalf of our clients, is we notify the beneficiaries on the front end that they are in fact named as a beneficiary within the estate plan. So like I said before, there's no formal reading of the will. This sort of takes the place of that, what you might see dramatized on TV. So it's usually a matter of us sending a copy of the will document to the named beneficiaries and giving them some background about how they're named, what they can expect as far as a timeline, because if we are probating the estate, we've got to get through that process, that administrative process, before we're in a position to distribute. It also allows us to find out if there's any special circumstances that that beneficiary has, so that we can determine, are they getting public benefits? Is this likely to disrupt their public benefits? Can we recommend that they meet with an attorney who might help them shelter their inheritance? Are they a minor? Is there an issue of incapacity? So these are things that we want to find out on the front end, which is part of the reason that we're reaching out to the beneficiaries early on, so that we can get a head start on any needs that they might have. Another thing that we're thinking about at this kind of initial or secondary stage of filing is preventing fraud. So we want to notify credit bureaus that the decedent has passed away, that they shouldn't issue new lines of credit to that particular decedent. We want to check and see if there's anything that the decedent maybe neglected or forgot they had during their lifetime. So we check with the state to see if any assets have escheated to the estate due to lack of activity. We want to see if there's any unclaimed property, like life insurance policies, anything like that. So it's our way of just making sure we've determined everything that the decedent owned as of the date of death. We're also going to start dealing with creditors, so any claims that are filed against the estate, we're able to respond to those claims right away. If they're legitimate, we're going to allow them to sort of sit, and we're going to pay them all at once after we know all creditor claims have been filed. Otherwise, we can negotiate, or we can even reject claims on the front end if we feel like there's a legal basis to do that. So that initial phase is really, there's a lot going on, because a lot of times executors don't have all the information. They don't necessarily know all the accounts, and so it's a little bit of an investigation to get that information. Phase 2 is really earmarked in the probate process by the filing of an inventory. And so an inventory is a schedule of assets, and it shows what the decedent owned on the date of their death and what the value was. So a lot of times during phase 2, we're getting that date of death value from banks or other financial institutions. We're having the real estate appraised so that we have a good date of death value to reflect on the inventory. Once that inventory is filed, really nothing needs to happen until the creditor period expires. So again, that 6-month period in Maryland and our 8-month period in Delaware. So we're kind of waiting out the creditor period. In the meantime, the personal representative is maybe simplifying the assets. So we're not keeping bank accounts scattered across multiple institutions. Maybe we're slowly collapsing those accounts into a single estate account, or maybe it's in an estate account and we're also sort of maintaining an investment account if we want that investment to conservatively grow, or at least not lose value while we're waiting out the creditor period. Sometimes it's a matter of selling real estate or selling vehicles and collapsing the value of those assets. And certainly on the front end, the personal representative is going to be dealing with personal possessions early on, because that's typically something that needs to happen before real estate can be sold, or in order to get out of a lease or something like that. So those are things that are happening on the front end. But once we kind of go through that initial evaluation and that cleanup process, we're waiting out the creditor period. Once the creditor period has expired, we can file what can be the final stage of filing with the Register of Wills, and that's called the accounting phase. So the accounting phase is sort of what it sounds like, and that's where we're reflecting to the Register of Wills, here's everything that came out, here's the claims that were paid, here's the expenses that were paid, here's the amount that's remaining within the hands of the personal representative and ready to be distributed out. Additionally, the accounting is where you would reflect any attorney's fees paid, any court fees paid, any probate fees, as well as what we would call a commission, which is the fee that the personal representative can take as compensation for the job that they're doing. So there is a reasonable standard in both Maryland and Delaware. So that's reflected within the accounting. Once the accounting is approved, and that can take some time, then we're finally in a position to wind up the estate or distribute the assets out. But during the accounting phase, a couple of things need to happen. We file that with the Register of Wills, and then any interested parties have a right to object to that accounting. And so there's this window of time where the Register of Wills is letting that sit of public records, so that if anybody has a valid claim or wants to contest the accounting, they have an opportunity to do so. Typically, that's a 90-day period from the day the accounting is filed. If we want to expedite that process, if the beneficiaries want to expedite that process, they can sign off on a waiver of notice and consent that more or less says, I know what the accounting says, I don't have any contest, you can go ahead and process the accounting. So if everybody has filed waivers of notice and consent, the Register of Wills can expedite their review process, and that will allow the estate to be closed at the Register of Wills level because the accounting has been approved. Sometimes it's not a one and done accounting. Sometimes there are still assets that have to be dealt with, and so you're filing a first accounting because you're required to within a certain amount of time from when the estate is open, but you might have to file a second, sometimes even a third accounting. Sometimes that happens because we have to sell real estate in order to satisfy debts, and sometimes that process requires special court approval. And so there's just some complexities that we have to deal with in order to close out or approve a final accounting with the Register of Wills. But as long as there's claims outstanding, including any mortgages against real estate, the estate can't be closed until those things are satisfied. So sometimes that's a reason for a delay. Even if everybody's on the same page, it can just be a little bit of a process. The winding up phase is really the distribution phase. So this is where, again, we're reaching back out to the beneficiaries. We're making sure that they know we've fulfilled our obligation with the Register of Wills, and now we're ready to distribute the assets. We typically prepare a summary of accounts for the beneficiaries at this phase, which shows similarly, here are the funds that came in, here are the expenses that were paid out, including any attorney's fees or commissions that were paid. And then we want to kind of list any specific gifts off the top that have to be distributed according to the will. And then any remaining residuary will be reflected and broken down on that sheet. So it gives the beneficiary sort of at a glance a 1 or 2 page document that says, here's a summary of how we handled the administration, and here's the resulting amount that's due to you. At that point, we also ask that beneficiary to sign off on a release. And the release says, once I receive this amount of money that the personal representative has reflected I'm owed, then I release that personal representative from further obligation. I agree they've fulfilled their obligation to me as a beneficiary. And that's a really important piece because we want to make sure that once the personal representative has completed their job, they don't have ongoing liability. So also really important to maintain really good records throughout the administration process, everything from the initial bank statements all the way through any new accounts that are opened and any copies of transactions along the way. And then of course, anything that's filed with the Register of Wills should also be maintained. And typically we tell clients to maintain those records for a period of 7 years. And we maintain them on an electronic version for our clients and provide them at the end of administration. So that's a long process, and it takes a lot of, for some people, they need guidance to go through that process. They need a law firm who is versed in this area of the law. Sounds great when I say it on this video, but when you're practically dealing with it, it can be overwhelming, and sometimes people just don't know where to start. So in addition to the probate fee, the other cost of probate is sometimes this cost of hiring an attorney to navigate that process for the personal representative. So when you hear people say, I want to avoid probate, what we just talked about is what they want to eliminate or reduce that burden for the person that's going to serve as the personal representative. A lot of times that person is a family member or a close friend, and so we want to make it as easy for them as possible. Another consideration about probate is everything we file with the Register of Wills is of public record. So some people don't want that information to be publicly viewed, whether that's information about what they owned when they passed away, who's going to get it when they pass away. That can kind of create maybe somebody who's an opportunist to sort of go after your beneficiary because they believe that they've received a large sum of assets. There's just lots of things involved with probate that a lot of people make the decision, I don't want my loved ones to go through that process. I want to choose something else. So that something else is creating an estate plan that avoids probate. So planning to avoid probate really should involve both a revocable trust and asset alignment. So let's talk a little bit more about what that structure looks like. If you hang around our office for more than a few minutes, you'll hear us talk about trusts as if they're boxes. And that's just a nice way for us to visualize a trust, because a trust is just a legal document. In reality, we're just creating this legal entity. But if we think about a box, we're creating this legal entity during our lifetime that's intended to hold certain assets so that that trust can do what it was designed to do, which is eliminate probate from my estate when I pass away. We use this concept of an open box when talking about revocable living trust, because I retain full access and control during my lifetime as the person who's creating that trust. So with a revocable living trust, I'm the creator or the grantor, I'm the trustee or the manager, and I'm the beneficiary. So because I'm sitting in all the seats, I have all the power, all the control. But here's the shift. If instead of owning my assets in my personal name, which I said earlier requires me to go through the probate process, if instead during my lifetime I align my assets with my trust, meaning I put certain assets in the trust by changing ownership, or I make it consistent with the terms of the trust by naming direct beneficiaries, then my estate plan is governed by my trust and my beneficiary designations, and we bypass the probate process and we just follow the terms of the trust. So probate avoidance is about shifting ownership of assets or how my assets pass, and the revocable living trust is the primary tool to sort of capture those things and eliminate probate from my estate. So revocable living trust, let's just talk a little bit more about how this trust works. So again, I have complete access and complete control as the person who's creating the trust, but I am going to build in a backup plan, because if you remember from our first series, first part of this series, we talked about the importance of creating a plan if I can't make decisions for myself at some point during my lifetime. So I'm going to designate what I call successor trustees, people who will take over management of the trust if for some reason I can't make those decisions during my lifetime and when I pass away. I can name the same people as incapacity decision makers, meaning they'll govern it for my benefit if I can't make decisions, or I can name different people, the same or different people for when I pass away. And that is the role more like a personal representative, where they're following my instructions in the trust and distributing my assets after I pass away. Asset alignment is a really critical piece of avoiding probate, and it's the thing we see people miss the most. People have a false sense of security. I created a revocable trust, therefore I've eliminated probate. But remember, revocable trust in and of itself doesn't eliminate probate. If you have an empty box, you have not eliminated probate. You have to go through the process of shifting ownership to the revocable trust and or updating beneficiary designations. So a piece on beneficiary designations. For the most part, we transfer ownership of assets into the revocable trust. With life insurance, we leave the life insurance in our client's name, but we name the revocable trust as the primary beneficiary, so it kind of goes into the box at the moment of death. But for retirement accounts, these are usually the kind of one exception to the rule. Retirement accounts are typically tax deferred. And so they have this special tax benefit that we want to preserve during our lifetime. So if I have a 401k or an IRA or a 403b, that means I invested pre-tax dollars. And then as I retire, or the government will sort of force me to withdraw money at a certain point, I'm going to withdraw money from those accounts. The taxes are deferred. I didn't pay taxes when I paid in, but I am going to pay taxes when I withdraw the funds. So that's a great income tax savings to me during my lifetime. And as your estate planning attorney, we don't want to disrupt that plan. So we want to leave those retirement accounts in our client's individual name, but we're going to lean on beneficiary designations to eliminate probate, because that's another way of eliminating probate. Depending on your plan and who you intend to benefit and if they have any special circumstances, a lot of times if we have adult people who don't fall into any special category, we'll actually name those adult people as the beneficiaries of the retirement account if they're also the beneficiaries of the revocable trust. And the reason for that is the IRS says that they get a continued stretch on those tax deferred accounts after I pass away. The rule is generally within 10 years of the date of death. So if we think about taxes as an important consideration, retirement accounts need to be in alignment with the overall plan, but we don't want to do anything that's going to jeopardize our income tax savings during our life, and we want to pass on any income tax savings to our beneficiaries. So if I name my 3 nieces and nephew as the beneficiaries of my revocable trust, they're all adults, no special considerations, and I have a 401k separate and apart, I'm going to keep the 401k in my personal name, and I'm going to name those nieces and nephew as my primary beneficiary on my retirement account. Whether they get the assets from the box, the revocable trust, or the retirement account, they're all getting things 3 equal shares. They're all getting things outside of probate, but they got the revocable trust outright, and they have the ability to continue to stretch out my retirement account or take it all at once. What one does doesn't impact the other. So this is just a concept that I want to put a placeholder in so that you understand not necessarily everything goes in the box, but everything should work in harmony together so that we get the best potential outcome. Maintenance is another concept that's new to a lot of people. I think a lot of us get through the estate planning process and they think, oh, thank goodness that's over. I'm so tired of talking about this. I'm going to stick my documents in a drawer or a safe, and I never want to talk about it again. But it is so important to understand that your estate plan should continue to evolve with you throughout your lifetime. Your assets are going to change. What you own, what you get rid of, what you acquire, it's going to change throughout your lifetime. Your family circumstances are likely to change. People will get married, divorced. God forbid they have a crisis within their lifetime, like addiction or a disability or something like that. You're going to have maybe grandchildren or great-grandchildren that are born, and you're going to want to incorporate planning that addresses those potential beneficiaries. So life is going to change. Our health changes, and so things that were important to us when we were in our 30s and 40s might be different than what's important to us when we're in our 70s and our 80s, and there's new planning opportunities as we think about those shifts. Also, the laws change, right? So when the law changes, we sometimes need to make adjustments to our estate plan. So we know that maintenance is really important, which is why we develop lifelong relationships with our clients, and we do that through our Bridge program. Our Bridge program is our maintenance program, and it's built to be an ongoing process, sort of like an insurance policy for the estate plan. So we're working with our clients annually to check on their asset alignment. Are things titled correctly? Are beneficiaries up to date? Do we have verification that everything was complete? We offer an annual meeting with clients in order to address any changes in circumstances, any updates that they might need to make to the actual legal documents. And then our job is to stay informed on legal changes And so we're able to inform our bridge clients of any changes in the law and recommendations we might have for them to make adjustments along the way. The whole idea of maintenance is we always want the plan to work because we never know when that day is coming. We don't know if we might become incapacitated, when we might need long-term care, when we're going to pass away. So we have to stay on top of it all the time. And if we make little shifts along the way, we have a much better chance of our plan doing what we expect it to do. The other piece of maintenance is informing future decision makers. So for those clients who enroll in our bridge program, they are able to have a family meeting after they've created and signed the estate plan. And so it's an opportunity for our clients and the attorney to meet with those future decision makers so we can talk to them at a time when life is good about, here's the structure of the plan, here's the job we're asking you to do, what questions do you have? And really what it's about is helping those future decision makers prepare for that future responsibility without the pressure and confusion that grief can add when we're otherwise thrown into it after we've lost a loved one or while we're helping that loved one navigate a change in circumstances. So everything about the Bridge program is about creating and maintaining an estate plan that works throughout your lifetime and especially when you need it to work. Okay, so that's how the revocable trust works while we're living. When we pass away, that trust is going to control what happens with our assets, much like a will would do in the probate process, but the trust is outside of that probate process. If I have a joint trust with a spouse, we can do that when we have jointly held assets and we intend for the same beneficiaries to receive our estate when we pass away. Then that joint trust will stay in existence as long as one of those spouses are still living. So when the first spouse passes away, we're going to pay final debts, taxes, and expenses. If they have that tangible personal property memorandum, that list that we talked about, we can get those personal possessions to the right people. But otherwise, everything stays put for the benefit of the surviving spouse, and they have every bit as much access and control as they always had during their joint lifetimes. When the surviving spouse passes, we're going to do the same thing. We're going to avoid probate in the same way. So ownership of assets is within the trust. The trust is going to control what happens if there are beneficiary designations on tax-deferred accounts. Those beneficiary designations are controlling. So if we have a joint trust, because we have a married couple, we essentially eliminated probate twice. When the first spouse died and when the second spouse died, it means that when a married couple created this plan from the get-go, they didn't have to worry about, well, I'll take care of all of this when the first spouse passes. They didn't have to worry about what happens if we die at the same time. Everything was dealt with in one uniform way so that we can eliminate all the worry, all the concern, all the extra work that would have otherwise happened when the first spouse died. So we've talked a lot about maintaining our estate plan. And so whether you enroll in a program like ours, which is the Bridge program that I talked about, or you're just navigating it on your own, I think it's really important to understand that maintenance comes down to triggering events, not necessarily a 3-year schedule or a 5-year schedule, which is something that we hear out in the community. I should review my estate plan every 3 to 5 years. And that's kind of an oversimplification because the truth is, in 3 years' time, nothing may change, but in 6 months' time, everything might change. And so really, if we think of it as triggering events, I think that's the better way to think about maintenance. So changes in the law that might impact your estate planning, changes in your assets. So if I close accounts and open new accounts, if I switch investment firms, if I acquire real estate or sell real estate, these are all things that need attention to make sure that if I have a revocable trust and I'm relying on that trust to control when I pass away, I want to make sure my assets remain in alignment throughout my lifetime. I want to make adjustments and talk to my attorney if there are changes within my family. If it's a concern to me and I'm worried about it, I should talk to my attorney about it because that attorney might have an opportunity or a planning mechanism that can help alleviate that particular concern. Another aspect, and we're going to talk more about this in our last session, is planning for long-term care. Maybe early when I started planning my estate and started thinking about it, I wasn't worried about long-term care. But as I get older and that long-term care event seems a little bit closer, I want to think about incorporating some type of plan that layers in some type of protection, allows me to get a proactive head start, or there's been a change in my health condition and maybe I need to take more aggressive measures to start sheltering my assets or securing needed benefits. And then also that idea of supporting your trustees as we go. We want to make sure that our trustees are well informed long before they need to act, because they're much better able to make informed decisions when they were armed with the information early on. Okay, so now let's transition into a case study. And I'm going to do this in two parts just to kind of pull together all the pieces that we learned about today. So in the first aspect of the plan, we're going to talk about our friend Sarah and her daughter Beth, as if Sarah had not done an estate plan. And then we're going to kind of rewind the script and look at it at what would have been a better outcome if Sarah had created a proper estate plan. Okay, so let's jump in. We have Sarah here, who is widowed. She has 3 children. Her oldest daughter is Beth, who is a significant support to her. Her assets look like this. She has a joint bank account with Beth listed as a co-owner, and that bank account is valued at about $15,000. She has a residence worth $450,000, CDs worth about $120,000, and savings worth $100,000. She has personal possessions, and she has a retirement account with $250,000. She's listed Beth as the primary beneficiary on that account. She has a will, and her will names Beth as the executor. It also, in the will, indicates that she wanted the house to be sold and divided equally among the children. So I want to talk first about what happens when what happens when Sarah passes away. So I want to kind of review the assets. So some of the assets were jointly held or named Beth as the beneficiary. So what is sort of concerning to me in this particular situation is Beth has been the significant support. So if Sarah listed Beth on her checking account because she just wanted Beth to have access, but she really wanted everything to go 3 ways, then that checking account can be viewed as a convenience account. And so it needs to be reported on the inventory through the probate process with the Register of Wills. And then either that or Beth's going to take the account, but then she's going to make gifts to her siblings if she wants to see through her mom's wishes. And so there may be some gift tax implications with her making gifts of that account to her siblings. So it kind of puts Beth in a difficult situation. We are, in fact, going to have a probate estate because we have assets in Sarah's personal name that exceed $30,000 in value. So I should have said that from the start, but we have a probate estate, and then how we handle that probate estate really comes down to what we want to have happen. We have a lot of clients who are under the assumption that I'm just going to name this one person to get everything, and I trust this one person to make it fair when I'm gone. That's not a great plan, because it puts that person in a really difficult position. And if they do something that they think is fair, but the ultimate beneficiaries don't think are fair, what you're doing is creating a lot of conflict between those individuals. So we encourage our clients to really think through, how do you want things to end up? Then let's figure out a way to get there. So when it comes to the convenience account, that checking account, we can report it as a convenience account, meaning it comes through the estate anyway, because Beth was just on there as a matter of convenience. Or we can let Beth keep it, but then she's going to have to reconcile everything on the back end. If Beth had died before she had a chance to deal with the distribution of the checking account, what's going to happen? It's going to fall within her estate. And so her siblings are never going to see that money. These are risks that we sometimes don't think about. We always assume my child will outlive me. There won't be a divorce. There are things in life that happen that we don't foresee. And if we plan properly within our documents, we can avoid those particular risks. The estate must be opened before Beth has access to anything. She will have access to the joint account, but she won't have access to anything else until she goes through that process of opening the estate with the Register of Wills. And then we would go through kind of this process of, is anything else missing? So marshaling the assets like we talked about in phase 2 of the probate flow chart. In order for Beth to open the estate, she has to file the petition, the original will, the death certificate. There are forms and affidavits that have to support her petition, so that's all filed with the original, with the Register of Wills. And then once she gets the letters of testamentary from the Register of Wills, she'll be able to apply for the tax identification number. She'll be able to open the estate account. Next, Beth will transition into marshaling the assets. She'll notify her siblings, provide a copy of the will, start to determine if there's any special circumstances that need to be addressed. And then she's going to go through the process of valuing the assets. So getting date of death balances, getting the real estate approved, getting the real estate appraised so that Beth can reflect all of this information on the inventory. The inventory is due 90 days after she is appointed. Then we wait out the creditor period. During this period of time, we are notifying beneficiaries. We're consolidating the assets. We're satisfying any valid claims and paying off certain debts. We want to make sure that any mortgage debt is paid for along the way, so that we can preserve the value of the house while we prepare to sell it. There is a process for Beth to make interim distributions. So if there's a need for some immediate money, she can do that. But I will tell you that a lot of times we discourage that until the creditor period fully expires, because there may be something out there that we don't know. And my general experience is once the money comes out of the estate, it's nearly impossible to get it back into the estate. We want to deal with any tax obligations. So filing Sarah's final income tax return in the year that she passed, and then filing future income tax returns on behalf of the estate while the estate is opened. Once we've kind of completed our work at this interim phase, we're waiting out the creditor period to make sure there's nothing new that pops up. Then finally, once the creditor period has expired, any claims have been satisfied, and in this case, once the real estate sells, because remember that was a requirement within Sarah's will, then Beth can file the final accounting. If the real estate doesn't sell by the deadline to file the accounting, she's going to file a first accounting before she can file a final accounting, which won't be until that real estate sells. So the accounting is a special form that's filed with the Register of Wills. If there's any new assets that pop up from the time of the inventory until the time of the accounting, they'll be reflected on the accounting. All creditor satisfactions will have to be filed by that time. There will be a probate fee. So we determined that the 1.25% probate fee in this particular case is going to apply to all of Sarah's assets. So we took the total value of those assets. We applied the 1.25%. And so you can see in this real life example that there is a probate fee of just over $3,600 that's due to the Register of Wills along with the accounting. Professional fees and court costs on a matter like this might cost as much as $8,000. And then once we file the accounting, if Beth's siblings don't file the waiver of notice and consent, there's a 90-day period that it sits waiting for the Register of Wills to review it or any objections before the estate can be closed. Once the estate is closed or the accounting is signed off on by the Register of Wills, Beth is in a position to provide the summary of accounts to her siblings, facilitate any releases, and then finally distribute the assets out. So as we walk through this case study, we can see that it could easily take a year for Beth to do the job that she was asked to do within the context of probate. So how might Sarah have prepared a better plan and eliminated probate altogether? So we're going to rewind the tape here and just assume that Sarah is sitting with us at our conference room table and we're planning the estate. So we would have counseled Sarah to create and fund a revocable living trust, this open box. Sarah would have been the grantor. She would have been the trustee or the manager. She would have been the beneficiary. She could have named Beth and then maybe her other children in successive order as her successor trustee. And so what that means is the moment that Sarah becomes incapacitated or the moment that Sarah passes away, Beth steps in as the manager of the trust, and now she has access and control. During Sarah's lifetime, Beth's responsibility is to Sarah because she's the primary beneficiary of that trust. When Sarah passes away, that responsibility shifts to the future beneficiaries of the plan, which was Beth and her siblings. So during Sarah's lifetime, she has full access and full control, but that concern she had with the convenience account, I need to make sure Beth has immediate access, is really cured or satisfied by the terms of the revocable trust because we've given that immediate access. The other really important piece of planning Sarah's estate to avoid probate is we would have looked at all of her assets and we would have fully aligned her assets. So when it comes to Sarah's assets, we would have deeded the residence to the revocable trust. We would have retitled her checking, savings, and CD accounts, and we would have covered her personal possessions with a simple document called an assignment of personal property, which is a way of saying I put all my stuff into my revocable trust so I can eliminate probate on the value of my personal possessions. We also would have updated the beneficiary designations. So on that retirement account, that $250,000 retirement account, we would have talked to Sarah. Sarah, I see that Beth is listed as your primary beneficiary, but you've just told me that you want all 3 children to benefit equally. If you want that to happen with all of your assets, we need to update the primary beneficiary on your retirement account so it lists all 3 children in equal shares. Assuming that was her intention, we would have had to change the beneficiary in the retirement account so it's in alignment with everything else she was doing. So in this case, when Sarah passes away, what does that look like from Beth's perspective as the now current trustee? So she would have had immediate access to the accounts. We do have to create a paper trail to prove that she is the acting trustee, and we do that with a certification of trust. It's a 2-page document that affirms Sarah is deceased. Here's the name of the trust. Now Beth is the current trustee. Here's the tax identification number. So that certification of trust is like an affidavit that accompanies the trust that proves to third parties like Sarah's banking institutions that Beth now has access. She's now the trustee of that trust, and she would have had immediate access. As trustee, she could also list that property for sale as soon as she was able to prepare her mom's house for sale. And the retirement account, Beth could reach out to the financial custodian of that account and facilitating getting claim paperwork out to herself and her siblings so that they could exercise their rights with respect to that account. So, a summary of benefits of planning to avoid probate. So, avoiding probate means we avoid probate and the filing fees associated with probate. We minimize attorney's fees because when we abbreviate the work that needs to be done, we've reduced the amount of attorney attention that's required. Reduces paperwork overall for people like Beth who are kind of standing in that position. Anything we can do to make that time in life a little less overwhelming is typically seen as really helpful to that future decision maker. It grants immediate access. We didn't have to wait to get appointed before we could access the accounts. And that's incredibly important because there are a lot of things that need to be dealt with financially on the front end when somebody passes away. Beth also would have the authority to make interim distributions. If she has a really good idea as to what expenses, what debts might be out there, then she has an idea of how much she can afford to distribute. If let's say her sibling needs to purchase a new car and so they need sort of $5,000 from their portion of the estate. If Beth feels that she has plenty of funds within the trust estate to deal with that, then she can make an interim or partial distribution on the front end. She's still going to want to wait out the creditor period before she fully distributes all the assets because there's always the potential that there is some creditor out there, and a creditor can open Sarah's estate even though Beth didn't have to open the estate. So there's still a little bit of let's wait and see before we make the final distribution. But it does mean the final distributions are faster because we don't have to go through that accounting phase or wait out the notice requirement, that 90-day period with the Register of Wills. So that wraps up our discussion today. I hope this was valuable to you. We talked about what wills do, how wills work within the context of probate. What does probate really look like altogether? Is that a process that I want to eliminate? If so, then we need to look at a revocable trust and our asset alignment and incorporate a plan to maintain that throughout our lifetime so that we can effectively avoid probate when we pass away. Hope this was helpful to you. We'll look forward to seeing you in the next session. Next time, we're going to be talking about planning for long-term care. So sheltering our assets in case we have a long-term care event. We look forward to seeing you then.